A company consists of two major organs, namely the shareholders and board of directors. The board of directors are entrusted by the shareholders to manage and direct the affairs of the company. Where the directors are the majority shareholders and act only in the interest of themselves, there may be a risk of minority shareholders to be at a disadvantage because they may find it difficult to obtain relief against the majority shareholders. And to protect the minority shareholders, common law has developed remedies. Furthermore, there are now statutory protections enacted under the Companies Act 2016 to confer rights and remedies on members in the event the controllers of the company breach their duties and abuse their powers. An analysis will be made as to whether the statutory derivative action introduced under the Companies Act 2016 provides a better protection for minority shareholders in comparison to common law. Now, before we go into the protection available under statute, Faith will give you a bit of background on the protection available under common law.
The case of Salomon and Salomon established that a company is a separate legal entity that has its own rights and liabilities. Further, Edwards and Halliwell states that courts generally will not interfere with the inner workings of a company, as its shareholders are designated the primary role of resolving any issues within the company. These legal principles contribute to the proper plaintiff rule, which is a principle laid down in the case of Foss and Harbottle, where it was held that the proper plaintiff was the company and not the minority shareholders seeking action. Additionally, if the majority shareholders of the company are in favor of its own actions, the matter may not be questioned again by an individual member. Unfortunately, while the proper plaintiff rule was meant to be a guardrail against excessive litigation, it is evident that it inhibits the ability for shareholders to provide checks on directors and majority shareholders, increasing likelihood for the latter to commit fraud or abuse their power, as can be seen in cases like Moyer and Waller-Steiner and others. Enter the case of Edwards, which has defined specific circumstances in which the proper plaintiff rule would not apply and the minority can take action. These exceptions form common law derivative action, which allows minority shareholders of a company to initiate action on a company's behalf. The first exception is when an act by the majority is ultra-virus or illegal. The court in Prudential Assurance Co. shows that where the alleged wrongdoing is ultra-virus the company, the proper plaintiff rule would not apply. This exception was also allowed in Taylor and National Union of Mine Workers, where a claim against an unlawful strike was allowed. Smith and Croft also showed how a claim against an illegal transaction was permitted. The second exception is where an act required the approval of a special majority which was not adhered to. In the case of Edwards, a resolution for increasing subscribers was invalid because a 2/3 majority needed to pass the resolution was not obtained. The third exception is where the act infringes the personal rights of a member or a group of members. Jessel MR in Pender and Lushington held that everyone in the company has a right for his vote to be accounted for, which can be enforced. Additionally, it is argued that where an infringed right is connected to rights stipulated in a company's constitution, all the more should the individual be allowed to bring an action. However, it will be tested to see that the claimants do not only have outsider rights, which would invalidate their claim. Further, the court will consider if the wrongdoing is a breach of the company constitution, which is actionable in court, and not just internal mismanagement, which is easily resolved within the company. Fourth is fraud on the minority, where the majority uses its power to discriminate against minority shareholders in the company. Various cases have sought to clarify the meaning of fraud in this context. Daniels and Berlin and Earl have opined that fraud can be acts that would benefit the majority and not the minority, and that these endeavors can be intentional, unintentional, fraudulent, or negligent. The recent case of Harris and Microfusion decided that fraud constitutes acts of dishonesty, and where that cannot be proven, fraud can be acts that only benefit the party in breach. Along with the need to show fraud, there must be wrongdoer control, where the alleged wrongdoers have control to prevent legal action from being sought on behalf of the company. In light of all this, common law derivative action has been abolished in the UK, and this is evidenced in the case of Bridge and Daly. However, recent developments have shown that common law derivative action can still be a tool utilized for multiple derivative action, as seen in the case of Universal Project Management Services. Additionally, the case of Boston Trust Company Limited saw the court allowing claimants to pursue common law derivative action in a situation involving multiple stakeholders, not just shareholders, even where the claimants lack standing. It should be noted, though, that this decision has been appealed and the final decision of the case is yet to be determined. On this side of the world in Malaysia, common law derivative action was valid until the Companies Act 2016 came into place. But similar to the UK, it is still applicable also for multiple derivative actions, as seen in the case of Ranjit Singh Siru and Zabarco, and where the company is in a 50% deadlock, as demonstrated by Perak Integrated Network Services Sendirian Berhad.
The common law derivative action has been described to be notoriously difficult to formulate and especially disadvantageous towards minority shareholders. For this reason, it has been expressly abolished by the Companies Act 2016, following suit from the United Kingdom and Australia. A derivative action is meant to provide for a fair cause of action, but the exceptions under Foss and Harbottle made it difficult. Thus, the introduction of a statutory derivative action is clearer and strikes a better balance between the rights of two parties. Prior to this, the Companies Act 1965 was the first to provide for a statutory provision regarding the bringing of a derivative action differing from the rules of common law, an action that has been long recommended in Malaysia. So, Sections 181A to 181E in the Companies Act 1965 enables current and former members and directors of a company to. As a whole, the Companies Act 1965 statutory derivative action has fairly filled the gaps of common law. To start with, the court, upon granting leave under Section 181A, may make an order for the company to pay reasonable litigation fees and disbursements by the complainant in connection with the action. This will go a long way to encourage shareholders' actions against wrongdoers of the company and alleviate their burden of the action. Secondly, an improvement can be seen in regards to locus standi, as decided in the case of Salcom and Muhammad Shoaib Ishak, the first time where the statutory derivative action was applied after its introduction. To compare, the requirements of a complainant were listed out under Section 181A4, while under common law, a former member or shareholder is barred from derivative action. Though from the case of Salcom, the key takeaway is that leave must be granted, but it must be granted on a high threshold. At the same time, however, the problem was that the common law action was not strictly abolished from application by the courts, and seen in 181A3, common law is not abrogated. This fusion of codifying the derivative action while not strictly abolishing the common law action causes issues when the courts have to decide which is to be applied. Hence the reason why it has been completely abolished in the Companies Act 2016. A reason as to why the common law action was abolished is due to a lack of certainty. This was seen to be an issue as to the requirement of leave granted by the court. In the case of Ramakrishnan and Syarikat Sendirian Berhad, the plaintiffs sought to rely on Section 181A on the grounds that the defendant had acted on the fraud on the minority. However, they had relied on the common law action in which the High Court had surprisingly accepted at first instance. Since it was brought by common law, leave of the court was not required. However, they must, and they failed in this case, to prove that it fell under one of the exceptions of Foss and Harbottle. They wanted to escape the statute where under Section 181B4 stated that leave was a requirement. This confusion between applying both statute and common law at the same time resulted in many unsuccessful claims by minority shareholders and is one reason why common law is abrogated. This is critical because essentially, a minority shareholder is trapped into common law merely for the fact that it has not been abolished and it is dependent on the court's discretion to apply it. From this discussion above, it has illustrated that the common law derivative action has given rise to several problems and hurdles in initiating proceedings. It can be concluded that the Companies Act 2016 has correctly abolished the common law derivative action to offer better protection to minority shareholders.
Thank you, Janice. As mentioned, the protection available for minority shareholders is provided for under statute. In 2007, the legislature added sections 181A to 181E to the Companies Act 1965, which permitted derivative action to be brought by certain persons on behalf of the company. Now, these provisions are retained in the Companies Act 2016 and are found in Division 6, Remedy Section 345, 347 to 350. Under the Companies Act 2016, Section 3471 provides that a complainant may, with the leave of the court, commose, intervene, or defend an action on behalf of the company. This section will be addressed in two parts. Firstly, pursuant to Section 345, a complainant is defined under subsection A to D. Thus, persons who can avail themselves of derivative action are wider, for the remedies pursuant to the derivative action are also available to persons who are not members but entitled to be registered, as well as former members. Secondly, Section 347, subsection 1 further uses the word initiate, intervene in, or defend a proceeding on behalf of the company. The High Court, in the case of Abdul Rahim Sulaiman, held that these words are meant that the complainant could only seek to leave, firstly, bring a new action on behalf of the company, secondly, intervene in the name of a company in pending action which does not involve the company, or lastly, defend a pending action against a company. So now that we have addressed who can bring upon a derivative claim, we will now look into the requirements to do so. The first requirement is that the complainant must give 30 days notice in writing to the directors of his intention to apply for leave under Section 348, subsection 2. The purpose of this is to give the company the opportunity to consider its rights and course of action. The case of Abdul Rahim Sulaiman held that notice in writing merely had to set out the intention to apply for leave, and that detailed information was not necessary. The 30-day notice period can also be shortened, as seen in the case of Ng Hoi Kyung, where the notice period was shortened to only 9 days. Additionally, there are two requirements which the court shall take into account when deciding a grant of leave. Under Section 348, subsection 4, in deciding whether to grant leave for the derivative action, the court shall take into account whether, firstly, the complainant is acting in good faith, and secondly, it appears prima facie in the best interest of the company. The first is whether the complainant is acting in good faith. The Court of Appeal, in the case of Salcombe, held that the test of good faith is twofold. Firstly, an honest belief on the part of the applicant, and secondly, the application is not brought for a collateral purpose. The second requirement is that it must be demonstrated that it appears prima facie in the best interest of the company for the application to be granted. The court in the earlier case of Salcombe adopted the Singapore decision of Pan Yong Hock, whereby factors to be taken into consideration would be whether the company stands to gain substantially in money or in money's worth, and whether the company has genuine commercial considerations for not wanting to pursue such claims. And this was cited in the case of Global and Property Development Sylvian Berhad. It is to be highlighted that retrospective leave is not possible, as seen in the case of Lim Ai Chin, as the words now used under Section 3471 of the 2016 Act is initiate instead of just bring. Next, where leave is granted, the complainant shall initiate proceedings within the court for 30 days for the grant of leave under Section 3483. The legislature also recognizes that the complainant would require assistance, and thus Section 350A to E grants the courts with a wide range of powers in making orders as it thinks fit when granting leave for derivative action, and these include granting specific directions for the conduct of proceedings, as seen in the case of Teo Get Luang, and even make orders in relation to legal fees. Lastly, to ensure that the complainant is serious in filing and conducting the derivative claim, Section 3485 provides that the derivative action, once commenced, cannot be discontinued, compromised, or settled without the court's leave. It is also noteworthy to mention that statutory derivative action is not available to a company in liquidation. Additionally, our statutory provisions do not expressly allow for multiple derivative action, and the court may also weigh the availability of an alternative remedy, such as winding up of the company, such as in the case of Pan Yong Hock. With that said, UTHA will now advise you on whether common law or statutory derivative action will provide you with better protection.
Thank you, Ashraf. Statutory derivative action under the Companies Act 2016 does offer better protection to minority shareholders. First, the criteria to allow statutory derivative action is clearly defined and wider in scope in comparison to common law. To explain, in Abdul Rahim bin Aki, Justice Gopal Sriram states that the real meaning of the phrase fraud upon the minority is unclear. A similar sentiment was likewise shared in the 2007 consultative document by the Companies Commission Malaysia, which henceforth will be referred to as the CLRC. Furthermore, common law derivative action is only allowed when the alleged company director personally benefits from the wrongful conduct, as provided for in Daniels and Daniels. In comparison to the common law ambiguity, Section 348, subsection 4 of the Companies Act 2016 clearly defines the two requirements that the court must consider for the application for leave to be granted. These requirements are good faith and in the best interest of the company, as explained by Ashraf earlier. Therefore, lawyers are able to better advise their clients with the two requirements in mind instead of grasping at straws, trying to figure out what the scope of fraud is under the common law derivative action. Additionally, Aiman Nariman opines that statutory derivative action is wider in scope because action may be brought for a director's breach of duty of care, which is illustrated in the case of Lembaga Tabung Angkatan Tentera, unlike at common law, where only a breach of fiduciary duty, such as an abuse of power, will give rise to a successful derivative action. Moving on, the second reason is that the court may make an order for costs under Section 350. The CLRC states that under common law, the complainant bringing the action is potentially liable for the cost of the proceedings, and even if the court makes an order of indemnity, this is usually after the conclusion of the case. In effect, this may disincentivize a complainant from bringing a derivative action. In comparison, Section 350, subsection D and E of the Companies Act 2016 enables the court to order the company to pay reasonable legal fees and disbursements incurred by the complainant, and costs incurred by the complainant, the company, or any other person. This is illustrated in the case of Tan Han Kwan. According to Aiman Nariman, reasonable legal costs may be awarded to the complainant even before the conclusion of the trial. Therefore, statutory derivative action better protects the minority shareholder because it reduces the financial barriers that the common law derivative action presents. Next, statutory derivative action provides better protection because claimants have easier access to information. Generally, a shareholder who is not part of the management may find it very difficult to get access to information. As such, it dissuades them from commencing common law derivative action. This issue was also raised in the CLRC. In contrast, under Section 350, subsection C, the court may make an order for any person to provide assistance and information to the complainant. This greatly benefits the complainant because with the order, he has unlimited access to the company's financial records and any other relevant information. Additionally, he may even be given assistance, such as affirming affidavits and statutory declarations. This provision was affirmed in the case of Global and Property Development. Alex, I'll pass it on to you now.
Thank you, Ufa. I will now discuss three more reasons as to why the statutory derivative action offers better protection. First, it is apparent that the issues pertaining to common law, specifically that of locus standi, have been alleviated under the Companies Act 2016. As recounted by the CLRC, there was considerable procedural issues of ascertaining locus standi, which results in a trial within a trial when one dealt with a common law derivative action. These issues have been partially rectified by the 2016 Act. As explained by Dr. Surana Banavan, the 2016 legislation grants standing to categories that are, quote, significantly broader than under the old law, even allowing for former members of a company, where the application relates to circumstances in which the member ceased to be a member. Indeed, as explained by the CLRC, the new legislation has implicit protective measures for minority shareholders, encouraging or forcing directors to be more vigilant in the management of the company's affairs in light of the additional classes of persons, with the result that the minority shareholder are placed within a better position than that seen under common law. Now, this protection also ties into another aspect in which the 2016 Act aids in minority protection, that of the changes towards the effect of ratification. According to Mohammed Rizal and Deborah Kwa, under the common law, a derivative action could not be brought if the breach could have been ratified by the company. Obviously, this caused great negative effects towards the protection of the minority, as any recourse would have been simply unavailable due to a simple affirmation of the majority. The 2016 legislation, however, following in line with Section 239 of the Australian Corporations Act 2001, fixes many of these difficulties. Under Section 349 of the Companies Act 2016, although ratification may be taken into account in relation to both the leave application and the substantive proceedings, the mere fact that a member of the company has ratified an action does not prevent a claim from being brought. Such a change, coupled with the many other factors mentioned by Ufa and myself, greatly aid in the protection of minority. Not only do the minority now have access to funds in order to carry out proceedings, but a wider class has locus standi and are not precluded from filing an action in light of ratification. Even so, and despite these numerous benefits, a question that remains is, does the statutory derivative action actually provide for better practical protection for minority shareholders? So in order to answer this question accurately, it is first necessary to discuss the practical results of such an action prior to the 2016 legislation. So as recounted by Vivian Chen, there were approximately 32 decisions involving shareholders' derivative actions from 2008 to 2015. Of this number, leave under the common law was granted only 13% of the time. Reasoning for this percentage is multivariate, with the main cause of refusal being a lack of locus standi, a lack of wrongdoer control, or for various procedural defects. Furthermore, in most of these 32 cases, costs were awarded to the successful party. Hence, quote, in line with a high proportion of unsuccessful derivative actions, cost orders were made against the minority shareholder in more than half of the cases. Certainly, the necessity of the minority to self-fund the case, the prospect of paying cost, and the low percentile of cases in which leave was granted acted as a great source of dissuasion against filing such a suit on the part of the minority shareholder. Such concerns, though, are rectified under the Companies Act 2016. Now, as mentioned by Ufa prior, by virtue of Section 350, the court has a wide gamut of powers, even extending to the granting of disbursements and fees towards the minority. In addition, it is now also the case that the minority shareholders have a substantially higher chance of receiving leave. Vivian Chen has recorded an increase of leave chances, with the exact figure tallying at 25%, a distinct and clear improvement over the status quo seen prior. As such, the minority shareholder, emboldened by the possibility of being granted fees to fund the suit, also has a higher chance of leave being granted, and likewise a lower chance of costs being levied against them. Nevertheless, it is important to highlight that these figures related to the statutory derivative action entailed in the Companies Act 1965. And whilst this comparison quote clearly indicates that cases decided by reference to the statutory derivative action have better outcomes than cases determined under common law, an exact tally for the 2016 Act is yet to be seen. Now, these numerous benefits within the law do not even begin to account for other factors, such as an increase of certainty as a result of the abrogation of common law. With common law being ousted, minority shareholders can rapidly choose to file suit, no longer confused by a choice between the common and statutory law, streamlining the process and unburdened with such difficult distinctions. Even so, no law is perfect, and the current legislation under the Companies Act 2016 does likewise have some issues. I will pass the floor to Ufa to discuss such. Thank you.
Thank you, Alex. It is worthwhile to note that whilst the statutory derivative action has a higher percentage of leave being granted when compared to the common law, it is a far cry from the 58% of successful leave as seen in Australian applications. In Ong Keng Huat, Justice Muhammad Nazlan notes that the requirement under Section 348 subsection 4 of the Companies Act appears prima facie to be in the best interest, while Section 237 subsection 2 of Australia's Corporations Act requires that it is in the best interest of the company. As such, Australia seemingly takes a more stringent approach due to the terminology used. Despite this, it is clear that the Australian courts exercise a greater flexibility from the higher percentage of successful leave when compared to Malaysia. Nevertheless, G. Lian Yap opines that it is a more streamlined and less complex tool for the minority shareholder and thus provide for better protection when compared with the common law.
With all things being considered, in our opinion, statutory derivative action provides better protection for minority shareholders compared to common law derivative action. Even so, greater flexibility on the part of the Malaysian courts may bode minority shareholders well within the long run. Therefore, it is advisable for you, Ms. Saratha, to take derivative action under the Companies Act 2016 in Malaysia, and we hope we have sufficiently answered your inquiries. Thank you so much and have a good day.